Let's go ahead and get started. Again, my name is Rick Kitson. I'm with the Cupertino Chamber of Commerce. Thank you for joining us today. Thank you also to our guest speaker, Rich Abdalah. Rich will talk a little bit more about himself and his experience that he's going to be sharing. We have a lot of questions. We're just going to go through the questions. If you have questions that come up, please ask them. Otherwise, I was talking with Rich before, 2 weeks ago. This was just not something that we were talking about. We were doing things like celebrating Songkran and having other things to celebrate. But as soon as the topic came up, suddenly everyone had a story. Everyone, unfortunately, has this shared painful experience. And so we just thought we need to be talking about this right away, just to see what can and cannot be done as soon as possible. So with no further ado, Rich, why don't you go ahead and get started and just tell me when you want me to pop up the questions.
Okay, I have been defending or handling the defense of ADA cases probably for about 10 or 15 years now. And there are overlapping laws that I'll mention in just a minute, which creates part of the problem. And the laws have changed a little bit over the last 10 or so years. The general goal of these statutes, federal and state, is to try to improve accessibility, if you will, for persons who are disabled, primarily wheelchair persons. And the problem has become that people who are filing these lawsuits tend to be multiple filers, and it's kind of sad in a way that some disabled persons are using the statutes essentially to, I think, make a lot of money. But anyway, be that as it may, that's where we are today. And I think part of the reason this came up in Cupertino was because recently there have been a large number of lawsuits filed regarding businesses operating in Cupertino. I think I've had 6 new cases in the last 2 weeks, and they ring fairly true in terms of the same kinds of claims. So Rick, let's start with our outline here. We'll go through it. And as Rick said, if you have questions as we go along, please ask, because I want this to be as user friendly as possible.
All right, let me go ahead and pull that up. All right. Everyone see it should be looking at a Word document.
Yeah, you want to read that first part out? Rick will read the questions and then I'll.
Sure. So you've heard about Rich. So this seems like a simple enough question, but I think everyone has been through this, and it's how we got started on this presentation. Now, what do I do? You know, this complaint shows up, and I know we've seen complaints where people have been contacted by attorneys saying that they know this business has this complaint, is expected to receive a complaint, or they have received a complaint already.
Right, I'll address that in a minute too, but I don't want to lecture about the laws themselves per se, because you're more interested in, well, now what do I do? But there's federal law, which is called the Americans with Disability Act, signed by the younger, I'm sorry, I can't think of his name, President
Brown?
No, President, the Bush, the younger
Bush.
President Bush in 1990. That sort of started things off. It's called the Americans with Disability Act. And then we have this act in California, which is somewhat parallel, or actually quite parallel, called the UNRRA Civil Rights Act. I'm old enough to know who UNRRA was. Are you, Rick? Are you old enough to who? Or do you
Would
know?
that be Jess Unruh?
Jesse UNRRA, yeah. He got his stamp on the Civil Rights Act, and it comes up periodically. All right. So are there both federal law and state law relating to ADA? Rick, I was going to have you read those. The answer is
Sure.
yes.
Okay.
There. So let's go to the next question.
Yeah. So how are these similar or different?
They're actually very similar in not quite a few ways. One of the biggest differences, though, is the California law is a little more disabled person biased, if you will. For example, unlike the federal law, California law says that there's an automatic $4,000 per violation, actually it's per visit, that is assumed in any case. A disabled person can maybe prove more, although I don't know how you actually prove damages in a case involving a person who's unable to access a business. But in California, you can't get around the fact that they have a $4,000 minimum assumed or presumed damages for any visit. There was some question for a period of time whether or not that was $4,000 per violation, meaning that if you had 10 violations, you're now looking at $40,000. However, that the courts have construed the statute charging, presuming $4,000 to apply only per visit. So if you have 1 violation or 10 violations, the presumed general damages is not to exceed, pardon me, is assumed to be at least $4,000. Otherwise, the laws are somewhat similar. California, and as I'll explain in a minute, does have a sort of a cure provision, but frankly, as I'll describe to you, it's not very helpful. So we'll talk about it, but it's not much use to you as a property owner.
So can the plaintiff claim federal law and state law violations in the same complaint?
Yeah, this is a little hard to understand for the layperson, but the federal courts and the state courts really have what's called pendant jurisdiction, which is legal jargon for a provision that allows a federal court to hear a federal law violation and a state law violation in the same complaint. So that's perfectly legal, and that's what you see all the time. You never see one but not the other. And in the 10 or 15 years I've been doing it, I've never seen one filed. I've never seen an ADA case filed in state court. They've all been filed in federal court. So, but yet they've included both federal law and state law violations.
So this is not one of our questions, but I know that there was some discussion that I've had with business owners that there was somehow an expectation that it would start at the state level, but your experience is that this always goes to the federal level.
I have never seen any case filed in state court. They've always all been filed in federal court. Most of them by the same person, by the same plaintiff. And the complaints include ADA violations and state law violations.
Okay, so you may have already answered this a little bit. How can a federal court decide whether there is a state ADA law violation?
That's again goes to this pendant jurisdiction. Federal courts are permitted to look at state court complaints that are similar in impact and similar in terms of what the facts may prove. So that allows an individual to file both in state court and federal court.
Okay. So what type of businesses, to what type of businesses does ADA apply?
Well, it's very broad. It applies to any business that's, the words are public accommodation. It's probably easier to think of it as any business that invites the public to come in and do business with whomever is the provider. So typical examples are going to be restaurants, stores, hotels, and anything that's open to the public. The Chamber of Commerce office is open to the public. So we have to
Mhm.
comply with the ADA laws as well. And it's very broad. It doesn't apply to apartment complexes or other businesses that are not open to the public.
So can I review the ADA standards myself to see if I comply with the statutes?
Yeah, that would be nice if we could. I don't particularly recommend that because the provisions are very complicated, and it really takes an expertise to evaluate whether or not you're in compliance. Rick, I gave you a couple of examples of
Yeah, let
what.
me see if I can. Oops. Is this it? No, that's. Let me find it for you. We have. Oh, right here. Okay.
A little before that. Okay.
Yeah, there we go.
Yeah, this is actually the picture on the left is not compliant with the ADA because the sink isn't in the right place. On the right-hand side is like a ceiling view or a vertical view or a view from the top showing dimensions within the bathroom. These are minimal dimensions in many respects, but you'll see from your own experience that ADA bathrooms tend to be larger than ordinary bathrooms. But you can see just in this picture alone the dimensions that need to be complied with in order to make the bathroom ADA compliant. But I have another slide that Rick's going to show now, which is a slightly different view.
Now, Rich, just to be clear, the dimensions that we're seeing on the right-hand side, those are compliant?
Yes.
Okay. But visually, looking at the left, that's not appropriate. That's non-compliant.
Correct.
Okay. All right.
All right. This is an example of a cross section of a bathroom. You can see all of the details that are required for the location of the toilet paper roll, the height and width of the grab bar. There has to be 2 of them. You'll see this little thing on the right-hand side that I've got the pointer on. That's a grab bar on the back. The height of that grab bar and the width of it is also dictated by law. The height of the toilet is dictated. The location of the dispenser for covering the toilet. I mean, it's pretty crazy. And by the way, bathrooms are a very common target for ADA complaints. Most bathrooms, especially in the smaller stores, are not compliant. So this is why I'm recommending that people not try to check the technical elements of compliance of an ADA just for a bathroom, for example, because it's just a little bit out of the ordinary person's understanding. I think the technical book for compliance with the ADA is like 260 pages long. So you don't want to try to become an expert on that, in my opinion, anyway. You can buy the book. It's public information. You can give it a shot. But when we remodeled the chamber offices a few years ago, we underneath the sink we put a cabinet for purposes of obviously holding paper toilet and so forth and so on, and paper towel. We had to remove it because you can't have anything under the sink that prevents a disabled person from moving a wheelchair up to and under the sink. So that's a little example of how it can be a little bit odd and highly technical at times. All right, let's go on back to the questions.
Great. Okay. Yeah, excuse me, I have quite a bit going on here. Thank you. And we just answered that. What if I had been sued? Can I do anything to avoid an ADA? Or if I haven't been sued, excuse me,
Right.
Can I do anything to avoid an ADA lawsuit?
You can. You can hire a qualified individual to inspect the property, and I'll describe a little more who they are. That is not an absolute guarantee that you will not be in compliance, or you will be in compliance with the ADA provisions, but it's the best thing you can do. Now, I'll talk a little bit about who can do that kind of inspection, roughly what it costs. And frankly, it will be a first if I have any client who calls me and says, gee, I did an inspection, ADA inspection 6 months ago, and now I'm being sued. It just doesn't happen that way. Most people don't even know the law exists and have no idea that they're not in compliance. So, okay, next question.
Yeah, and also to that point, Rich, we were speaking to the City of Cupertino Building Department, and they really had a very similar response. When something is approved, it's their understanding that when a building is improved, it is compliant, but that doesn't necessarily mean anything.
That's absolutely true. A lot of buildings were met code 15, 20, 30 years ago when they were built, but the codes change. And this, of course, was added in 1990. So frankly, anything built before 1990 is probably not in compliance unless somebody is updated. If you go in to do a remodel like we did with the chamber, or if you'll recall, the Starbucks did a remodel, the one located at the corner of
Stevens Creek and Dianza Boulevard.
Yeah, I don't know if you remember or not, but there used to be a zigzag. There still is a zigzag stairway at the sidewalk. Well, when Starbucks went in to remodel the property, they had to actually make access all the way from roughly from the street, or pardon me, the sidewalk, all the way up to the Starbucks. And if you drive over there, you'll notice there's this big kind of vertical or hump really that's in the street, pardon me, in the parking lot, and goes from the sidewalk up to the Starbucks facility. So, if you go in for a remodel, then you have to update. That's something to think about when you're considering going in for a remodel.
So what are the most common ADA violations?
All right, the most common violation, the one that we see in almost every complaint, is the parking. The exterior parking does not comply with the code. Accessible path and entry is another hot button. Parking count, the number of disabled parking spaces that are required per unit. Also parking access aisles. Lately, it's been door handles. If the door handle is round, like most of us have, in our homes, that's not ADA compliant. It has to be a door handle of such a nature that you don't have to put pressure on and turn it with your hand, like a handled, door handle with a little catch on it on the side. That would probably be compliant. Bathrooms are a very common target for ADA complaints, and frankly, they're pretty vulnerable, if you will. Customer service, curb ramps, customer service counters. You have to, most counters are not at the right height. And if you'll go into some places, you'll see that they have a counter that's lower than all the rest of the counter. And that's probably due to compliance with an ADA situation. So those are the most common areas. Oh, by the way, customer seating and tables wasn't a common area until the COVID situation arose. And I'll kind of get into that a little bit more later.
So am I entitled to a warning letter before a lawsuit is filed?
No, and that's pretty disturbing. What was happening until the law was changed in California a couple of years ago was that disabled persons and lawyers would be, mostly non-lawyers, would be sending letters saying, gee, I've been to your restaurant or I've been to your store and the bathroom isn't compliant. And if you don't pay me $5,000 or $10,000, I'm going to file a lawsuit. Those letters are now prohibited. The newest thing, and I'll explain it a little bit more in detail, is once a suit is filed, you may get a letter from a lawyer saying, hey, I'll be glad to represent you, but we'll get that in just a minute.
Okay. Am I liable under ADA if I did not know that my business did not comply with the ADA law?
Yeah, that would be nice. Unfortunately, it's what's called a strict liability statute, meaning knowledge is not required. That knowledge of the violation is not required. And it's a little bit unnerving when folks find out that they have a bunch of violations and they didn't even know it because no one's ever said a word to them. All right, next question.
Yeah, and this is something that we've seen just in the last week. If I receive a letter from a lawyer offering to represent me along with a partial or full copy of an ADA lawsuit, is that service of the lawsuit?
Now, I've seen a number of these recently. And what has been happening is a couple of lawyers have somebody who checks the public website for federal court, I guess, on a daily basis. As soon as they see that a lawsuit's been filed, since that is a public site, they can actually download the entire lawsuit. Lately, I've noticed that they've just been downloading like the first 2 or 3 pages. They then send a copy of the letter to the tenant, usually the tenant and or the property owner. And how do they find out the address? Because it's usually in the complaint. The complaint has to specify where the ADA violations exist. So the lawyer then has the information about who's involved, where the property is located, and then they will send out these letters saying, gee, I understand you've been sued. I will be willing to defend you. That's not illegal. It is a disturbing though, because when the person receives that document, the question is, well, have I been served with a lawsuit? And what do I do? So that's a long-winded answer to when a person gets one of those complaints with a lawyer's letter attached. No, that's not technically service of the complaint, but it can sure appear to be service to the average layperson.
Great. And then I just want to take a break here. We're covering ground. As I indicated before, we had tried to gather as many of these questions ahead of time so we could answer those that we knew were floating around in the community. But if you have a question, please ask, raise your digital hand or enter the question in the chat and I will call on you. Great. Next, I've heard that there is a law that allows a defendant to make repairs and reduce exposure.
Okay. California law does have a provision, and I'll just give you the general concept that if you're in the middle of doing a CASP inspection, or pardon me, repairs, and you get sued, you have a sort of a window of opportunity to finish those repairs. That's not very common, but in fact, I've never seen it happen. I've never seen anyone in the middle of a repair job for compliance with ADA to be in the middle of to be sued at the same time. Yes, and then by the way, that's a California law which reduces the damages, the presumed damages, from $4,000 down to $1,000 or $2,000, depending on the size of the business. The problem is, even if you do that, you don't escape the lawsuit. You're still captured in that lawsuit. The other problem is the California law doesn't have any impact on federal law. So I'm not so sure that it really makes that much difference that you comply with that. It doesn't get you out of the lawsuit. And if you think it does, that's a mistake. So that's what we're talking about. A lot of people have referred to that, and it's limited to only California statutes. And it doesn't, frankly, it doesn't help that much. If you are in the middle of it and you do get a lawsuit, yeah, then you can talk to a lawyer and find out what you can do.
So this is an important set of questions here. Everyone's new best friend. What's a CASP inspector? What do the initials stand for? And how much does it cost? Is it worth it?
All right. A CASP inspector is a person who's qualified and licensed by the state of California to conduct inspections specifically and only for ADA compliance. They're not building inspectors. There's no reason why they couldn't be licensed building inspectors or licensed contractors. But you don't have to be a licensed contractor to have a CASP license, if you will. And CASP stands for California Access Specialist. And those reports can run you They used to be pretty reasonable, $500 to $1,500, but now they run around $2,500 on up. That report is very thorough. It will usually cover the exterior of the building and the interior. You can, of course, limit the inspection to the interior if you happen to be a tenant and you only want to know, I only want to know about the interior of the building. That's my responsibility. Everything outside of the building is the landlord's responsibility. You can limit the inspections. It's your call. And, is it worth it? For peace of mind, I certainly would think so. As Rick said earlier, a CASP report that is, 2 or 3 years old may or may not be up to date. They may have changed the laws, which they do periodically. So I think it's worth it. But if you do a CASP inspection and the inspector finds 10 or 15 things wrong with the report, wrong with the property, then that inspection report does become discoverable in litigation. So I will explain a little later why that's not, may not be the right thing to do, especially right now. I'm getting clients who are doing the CASP inspection after they've been sued and then contacting me. The first thing I say is, well, why did you do that? Because that report can be provided to the other party, and frequently the complaint only alleges 1 or 2 violations. The report may have 10 or 12 violations, and that report then becomes discoverable. So you kind of have a little bit of a problem there.
So, so what you're saying, Rich, is certainly after the complaint has been filed, running a CASP inspection could really just become a longer inventory of potential violations or of documented violations, which is really just ammunition for the other side.
Right. And if the lawyer asks for the CASP inspection, it's a protectable document. If the client asks for and pays for the inspection, especially before litigation, or even soon after litigation, then that report becomes discoverable. So far, it hasn't come back to bite my clients yet, but I can see it's a problem. So you could do the CASP inspection to say, I want to avoid lawsuits altogether. Will that work? Hopefully it will.
Okay, so there's a certain, I guess we're in the age of vaccines, so there's a certain inoculation against future litigation, but it doesn't indemnify.
Right, and I have never had a case where the client who calls me says, gee, I had a CASP report done 6 months ago. Most people just don't know about it until it's too late. And that's a problem.
Well, we'll get other questions, but this is something the Chamber and the City of Cupertino have been looking. We discussed this, and we're looking around, and we're exploring the possibility of putting together a subsidized program to make it much more affordable for everyone and anyone who's doing business in Cupertino to get an inspection should they wish to have one. And that's something we're actively exploring right now. In connection with rental property, this is very common, as you had indicated. Who is responsible for ADA compliance outside the lease premises and inside the leased premises?
Outside the leased premises, usually that is the landlord's responsibility. Inside the leased premises, in other words, the area that the tenant operates in, is typically under most leases that I've seen are the tenant's responsibility. In large part, that's because the tenant's activity affects what is permitted within the leased premises. So most leases, and I have an example, I don't know if you want to show it.
Yeah.
At this point. Yeah, let's take a look at it. This is a lease that's what's called a California Association of Realtors form lease for commercial property. This is probably the most specific and explicit lease provision that I've seen that refers to the Americans with Disability Act. What this says is the tenant is responsible to make sure that the lessee's premises are in compliance. So if you look at 49B, it says just what I've been referring to. Since compliance with the Americans with Disability Act is dependent upon lessee's specific use of the premises, lessor makes no warranty or representation as to whether or not the premises comply with ADA or any similar legislation, California law. In the event the lessee use of the premises requires modifications or additions to the premises in order to be ADA compliant, lessee agrees to make any such necessary modifications and or additions to lessee's expense, at lessee's expense. That's as I say, that's a very explicit provision. Normally, what I've seen in most leases is that the burden and cost of maintaining the premises within up to code, even code modifications or code changes, is the responsibility of the tenant. So it would be very unusual, and if anyone has a lease that says that the landlord will take care of the interior, that would be a little bit surprising to me. Part of the reason is what's just stated in that document, and that is, if I have a restaurant, I have to have a bathroom. Why do I have to have a bathroom? Because the health laws in California require that I have a bathroom. But if I have a auto parts store, I don't have to provide a bathroom. So if I am required to have a bathroom because I operate a restaurant, then I have to make sure the bathroom's in compliance. If I operate a car parts store, for example, and the bathroom is not open to the public, then I don't have to worry about complying with federal or state law.
Okay. And I'll pull up our next question, which is, any questions for the audience from the audience? Well,
I see one question here from Rose. And the question is that, and we can all see it, have you seen lawsuits on properties or businesses which have had a CASP inspection? Not so far. And that's probably the best way to minimize the likelihood of exposure. So if you have a CASP inspection and there are specific problems that need to be addressed, you've got to address them. If you don't fix the problems, then that doesn't do you much good. But so far, I have not had any clients come to me who have had a CASP inspection sometime in the past and have been sued. That doesn't mean that there aren't any. It's just been my experience. I've probably done about 25 or 30 of these cases over the last 10 or 15 years, probably a third of those cases in the last few months, frankly.
so if I'm a tenant and the claims all relate to my rental premises, why is the landlord also named as a defendant?
Yeah, this is very upsetting, I think, to most tenants and landlords, frankly, because the defense has to be provided for both the tenant and the landlord. If the landlord decides I'm going to hire my own lawyer, you hire your own lawyer, tenant, then the tenant will be looking at two bills. So two attorney's fees bills. So what I usually do is encourage the client to enter into a conflict release, if you will, or waiver with the landlord and defend both the landlord and the tenant. And the tenant will usually pay for that because they're gonna have to pay for that time anyway. The landlord has little or no ability to resolve ADA non-compliant elements within the lease premises. That's entirely, within the tenant's control. So, I've been doing this pretty regularly, and landlords are pretty good about it. I haven't had any landlords say, well, no, I'm going to hire my own lawyer, and then we're going to pursue the tenant for our costs. So that's what I always encourage people to do. Why are they both named? Well, ultimately, under the law, the landlord or the owner of the property is responsible for the condition of the property. Contractually, pursuant to the lease, it's often the ADA upgrades or compliance is usually contractually contractually given to the tenant, as we've just seen in the lease we just took a look at.
So and that touches on the next question, which is how is responsibility for making ADA upgrades usually covered in lease agreements?
Yeah, this is a little bit redundant from before, but you saw the provision that we just looked at in the CARF one. Some of the provisions are in leases relating to the tenant's responsibility for making ADA upgrades. It's usually a little more subtle than that, but usually the provision says the tenant is responsible for any code changes or upgrades that may have occurred in the last year or so. Am I still on there? Oh, okay, here we go. The landlord is usually responsible for the exterior of the property. The exception might be where the tenant has what's called a freestanding individual or single tenant freestanding building, and they have responsibility for the parking lot, the sidewalk, and so forth. That in that situation, the tenant has really leased everything. And if there's exterior non-compliant ADA situations or problems, the tenant's probably going to be still responsible for it.
So how can I convince the property owner to help me financially to make ADA upgrades?
It's not a bad idea to talk to the landowner, property owner, especially now, and see if you can persuade the landlord to give you somewhat of a break on the rent, maybe for some period of time to help offset the cost of these ADA upgrades. And they can be very costly.
Have you experienced that happening?
Very rarely, but the situation's changed now. A lot of tenants are struggling, and landlords may be a little more inclined to do that, especially when you're paying for the defense of the landlord in an ADA situation. And also too, if you say, look, if I have to make these upgrades, I'm going to have to file bankruptcy because basically it's going to wipe me out. A landlord may be inclined to say, well, what if we compromise your rent for a while, and will that kind of help offset the cost? So I think you can always ask, and some landlords recently I had a landlord agree to pay for half of the retainer in my case, although by the time I went back and forth with the landlord's attorney on the wording of the waiver agreement, I probably spent 2 or 3 hours. It's kind of silly, but there is nothing preventing a tenant from saying or asking the landlord to if they will share in the cost of the upgrades or the cost of the settlement. And of course, the landlord is not obligated to do so, but may do so, particularly in these COVID times that we're experiencing.
So you had mentioned attorney's fees. So who pays the property owner's attorney's fees to defend an ADA lawsuit that involves only a specific rental unit?
All right. So the situation is the landlord has been sued as well as the tenant, which is 100% of the cases that I've had where the problem is the tenant's unit. If the landlord decides to hire their own attorney, they can look to the tenant to reimburse them for those costs. The problem, of course, is that the attorney's fees charged by the property owner are not, you really can't influence those. They're really, the property owner's attorney is essentially responsible to the property owner. So they almost have almost a open checkbook on that. So that's why I really encourage tenants to offer to pay for to bring the landlord in as a co-defendant that your attorney is going to represent, and agree to pay for the attorney's fees and whatever settlement is necessary. So there's just no point in letting the landowner incur more fees. It's just going to double your bill, or depending on the landlord's attorney's fee rate, it might triple or quadruple your bill.
So that's a little counterintuitive, but
It is.
I understand what you're saying, where being proactive, and if you could combine that with some sort of rental discount, that would make it much more cost effective to defend. Now,
Go ahead. the landlord hasn't been served for months. And so my tenant has to answer the complaint. But since the landlord hasn't been served yet, technically they don't have to answer the complaint. I've actually seen situations where they want to settle with the tenant, but not necessarily the landlord who hasn't been served. So, you know, there's another reason to offer to indemnify the landlord. If the landlord has to pay anything to defend itself in these cases, they could definitely come after the tenant for reimbursement.
Now, speaking of this specifically and only in terms of legal strategy, so then the complainant has an incentive to divide and conquer, as it were. They can perhaps make more money filing separate complaints.
I think so. And as I say, it gets very tricky when your client, let's say the client is a tenant, they've been served, but for whatever reason, the landlord hasn't been served. And so you file an answer for your tenant, and then the landlord gets served some months ago, and the inspections have already occurred. It's a nightmare. It's almost like conducting two separate lawsuits. So there are a number of reasons to be proactive as the tenant and bring the landlord in as a co-defendant and agree to represent them. Again, there's a savings virtually by what I do for the tenant and the landlord is very much the same as what I would do for the tenant alone. So the cost factor is important, and it certainly helps to keep the cost down if you're defending both the landlord and the tenant.
Well, this next question is something we've seen an awful lot of lately. Has the pandemic affected ADA complaints? If so, how?
I think it has, in large part because the most common plaintiff, and we'll talk about him in a minute, in California, can't go in a lot of the places because they've been closed by law. And since they haven't been able to go into the premises, most of the lawsuits that we're getting now refer to either the door to enter the premises or the tables and chairs outside in front of the premises. They're non-compliant. So I think there has been an impact. I think it's a pretty good defense. I have one case right now where they're claiming that the tables and chairs inside the leased premises are non-compliance. My client says there were no tables and chairs inside for customers because due to the pandemic, we had put those all and stacked them in a corner. So the question is, did this guy ever actually come into the property? I'm getting a little on the side here, but the ADA plaintiff very, very rarely ever actually goes to the property. Typically what they do is they send a kind of like a tester, and that person sees whether or not there are any violations, then they report back, and then a lawsuit's filed. The way it's being conducted right now is essentially, frankly, it's a way to get money, and most small companies or small businesses are just not prepared to pay a lot of money to defend these cases. I'm getting a little off track here, but go ahead.
No, that's yeah. There's a world of anecdotes, which I think we're appreciate framing that with your experience. Will attorney's fees and damages expense in connection with an ADA lawsuit be covered by my property insurance?
The answer to that question is probably no, in part because property insurance is usually intended to cover what are called sudden and accidental. You have a broken pipe, or there's a storm and the roof collapses as a result of weight on the roof, or there's a fire that occurs overnight, or something that's just, as I say, it's sudden and it's accidental, as opposed to a code violation. No, that's probably not going to be covered. Now there are policies, and I've not seen any myself, but maybe some of you have, where you can get coverage for attorney's fees in certain kinds of lawsuits, but not damages. I believe that that's available for sexual harassment litigation. In other words, the policy pays for the cost of the attorney, but doesn't pay for damages. So if anyone has a policy that pays for attorney's fees defense of an ADA lawsuit, please tell me, because I just haven't seen one yet.
Now, if I refuse to settle and win at trial, will the court award attorney's fees against the plaintiff?
All right. This seems to be one of the most unfair parts of the law. If a property owner wins, if a complainant, a disabled person plaintiff wins an ADA case or an UNRRA case, under the law, they are entitled to reasonable attorney's fees. It's not uncommon for those fees to far exceed the amount of the presumed damages. It would not be unusual for a court to award $4,000 for damages to the plaintiff and $100,000 in attorney's fees. We see this a lot. Okay, so turnabout's fair play. So if I'm a defendant and I go to court and I win, I should get the same consideration? Well, unfortunately, that's not the way the law is written. The statute says that unless if the defendant prevails, property owner or tenant prevails in a lawsuit, the court can only award property damages if they decide that there was absolutely no basis for a lawsuit, or the lawsuit was groundless, or what we call frivolous, meaning it was just not really important, or the alleged violation was so minor as to be kind of like unimportant. So bottom line, if my client says to me, I want to take this all the way to trial because I don't think this guy ever came to my place, I said he probably didn't. Although I have found by and large that the alleged ADA violations in these lawsuits are usually correct. So you have this dilemma. Well, he's right. The parking space is non-compliant, but I don't think the plaintiff, ever visited this place. So it's not a win-win proposition for the defendant. It's a lose-lose, frankly. So that's why, one of the jobs of the attorney is to try to get the client to understand, this is not in your best interest to take this thing to trial. Here's why, and I'll explain. It seems totally unfair. That's the way the law is right now.
So, Rich, would this be an opportunity for some sort of legal reform or legislative reform to allow for the court to award attorney's fees?
Yes, but I think it would take a miracle to make that happen. The concept is to encourage plaintiffs in the private sector to essentially do what the government isn't willing to do. They're not willing to hire people to go out and make checks for ADA compliance. And so what they're doing is they're essentially hiring lawyers, if you will, by offering a bounty in the way of attorney's fees to go out and file these cases. Is that right or wrong? I don't know. I mean, I don't think it's fair. And I think that it's the fact that the plaintiff gets attorney's fees, even if they far exceed the damages, but the defendant gets virtually nothing, even if they prove the defendant was never there. And so they could not have encountered any barriers. It just seems grossly unfair, but it's not uncommon.
Can I claim the cost of making ADA upgrades on my taxes?
There are provisions in the code. One of them is described as the Disabled Access Tax Credit. This is especially for small businesses. I would suggest that you contact the CPA or your tax accountant or tax attorney and see. Now, this law would allow you to perhaps take a tax deduction or a tax credit for the modifications that you have to make to the premises, which can be expensive. I just had a client put in a compliant parking space in a small strip mall that she owned. It was a $45,000 fix, and fortunately, she was able to cover the cost. But that is really very high. So you have to kind of take a look to see if you can get credit. You won't get credit for the money you pay to the other side for settlement of the case. So that's probably a difference you need to take a look at.
So you maybe you can talk about that a little bit with this last question, which is what should you do if I'm served with an ADA lawsuit?
Okay.
Um,
All right, let me touch on that.
you use the S word.
Well, let me just say, anyone who's participating today, if the plaintiff in your case is not a guy named Scott Johnson, let me know. Raise your hand, electronically. Every case that I have had, with one exception, it involves a Scott Johnson. If you look Scott Johnson up on the internet, on Google, you'll find a lot of articles about him, and they're not particularly flattering. Nevertheless, what he's doing apparently is slightly compliant with the law. I don't believe that he's going out and actually inspecting these places or taking a look at them. He's got a little machine going on for him of lawyers in Southern California and so forth. So, but if you get that lawsuit served on you, take it seriously. You might want to contact your insurance carrier to see if there's any coverage for the defense costs. I have suggested that if you're a tenant and you're served, to contact the property owner and try to coordinate the defense of the complaint. I've never had that backfire or cause a great problem, so I think that's a pretty good idea. Consult with somebody who has ADA experience, a defense lawyer, or someone who knows about these kinds of problems, and you can decide, well, what are my options? How do we get this resolved? What's going to cost me? And do I need to hire a lawyer in the first place? Another thing I would suggest is do not have your CASP inspection performed before you consult with an attorney. For the reasons that I mentioned earlier, that is that report may contain many more ADA non-compliant situations that are not mentioned in the complaint. I have found, generally speaking, that they don't do a particularly thorough job in terms of these inspections, in part because this last year, they can't get into the properties in some situations. And the last thing I would say, just one more thing.
Go ahead.
You have 21 days to file an answer to the complaint. So you need to kind of move fairly quickly to try to get some help. That's it.
I wanted to circle back to the CASP inspection, because that's the closest thing that appears to be proactive, addressing both the intent of the law, providing access, and helping business owners do that in an appropriate fashion. If an attorney were to order that report, my understanding of your earlier remarks is that is not discoverable then?
That's correct. By and large, it becomes my work product, meaning if I'm going to hire an expert, but if I decide that CASP inspector is going to testify, then that report would become discoverable. Mm-hmm. But if the client has the report done before any litigation or on their own, even after litigation, then it becomes automatically discoverable. I can't say it's covered by or protected by attorney work product. So I'd suggest we hold off on that.
Great. Okay. Other questions from the audience? I know we have a world of woes and experience here in our audience, and
okay, is the chamber going to try to put together some kind of a, I don't know, program?
Yeah.
What do you want to call it?
Yeah, it's we've already spoken with we've spoken with dozens of local businesses. Many have whom are been impacted by this. And those who haven't been recently appear to have been dealt with this situation, if not this very same individual previously. So we're actually looking at other programs that have been run in other communities to try to help prevent the easy money. You know, really to proactively and subsidize and otherwise underwrite some of the costs of these CASP inspections, so that if we can make small businesses in Cupertino a harder target, and that is to say to have our small businesses better able to provide services to the entire community, that's good for everyone, and makes life a little bit more difficult for people who are unfortunately seem to be in this line of work for just the money.
Frankly, I've yet to see any lawsuit that wasn't really about the money. And I do urge clients to go ahead and make the changes or improvements that need to be made. And I've had a situation where my client has settled a case, but before they get a chance to make the improvements, another disabled person comes along and files a lawsuit. That's not illegal. So we ended up having to settle 2 lawsuits on the same property. So it's important to make those changes. That's pretty unusual to have these back-to-back lawsuits, different people, different plaintiffs, but it's not illegal. So it can be very costly.
What about having you settle a lawsuit for a certain set of violations, and then the same complainant will come back with a different set of violations?
Technically, that's possible. And that's why it's probably helpful that if you settle a case, definitely take care. You might want to do a CASP inspection and say, I want to make sure I'm in compliance. The most vulnerable businesses for these folks are businesses that offer bathrooms, because as I just showed you a little bit ago, bathrooms are very hard to upgrade. Well, they can be very hard to upgrade to, especially if you've got 1 bathroom for public use, or even 2. Sometimes you end up having to combine 2 bathrooms in order to comply with the statute and make it 1, unisex bathroom. So I still encourage my clients to make the changes, because anybody else can come along at any time if you haven't made any of those changes, or they find new items and file a lawsuit. We're right back where we started from.
Right. Any questions? Any questions? Well, thank you, Rich. I don't see any more questions. This session has been recorded. We'll be sharing it on our website, which is cupertino-chamber.org. We also have YouTube, which is Coop Chamber TV, or if you just search the Cupertino Chamber on YouTube, you'll find it. Thank you so much. Rich, if there's follow-up questions, I don't want to offer your time for free.
If you want to send me a question, an email question, you can call Ricky, has my email address, or you can look at my website, frankly, I have my email address there.
And this would be relating to this, and obviously if there's more involved, we'll work that out. But especially in this subject, the most expensive questions are the ones you don't ask, and you don't know that you don't know, right? So it's really important to ask. So thank you so much to everyone. Thank you, Rich, especially for your time, and be safe, be well, and let's get back to business.
All right.
Thanks, everyone.
Thank you.
Oh.